Do you know what you get from your broker? Do they supply business cards?
No.
You do. Do they supply, do they give you a salary?
No.
Some will even charge you to sit at your desk.
Rent.
My mother
Yes,
did.
rent. So again, always the name of the brokerage, licensee's name, if used, must clearly state the name of A, the brokerage, B, the last name of the licensee as registered with the beeper. Now again, sales associate's name not required in advertising by regulation or law. If used in advertising, clearly states the name of the entity and the name of the associate in addition to the brokerage entity as registered with the beeper. So now you're going to look at an ad. You tell me this is compliance with law and rule.
No.
It's got the name of the brokerage, doesn't it?
Yeah.
But not the name of the guy.
Could it ever be compliant in law?
Yes. Yep.
How?
Blind eye.
Elton John. Olivia Newton John.
Last name?
Rarely a last name, but actually we normally use John as a first name. So again, compliant up to there, and again, legal, the last name as registered with the beeper. Just Mr. Brown would have been perfect along with ABC Realty. And this allows a member of the public to go to the public records and see if either the brokerage or the sales associate has been disciplined. This is public protection. Now again, blind advertising of brokerage services in the state of Florida is simply illegal. By the way, there are many brokers who use Craigslist. And guess what they don't do? Discloses brokerage advertising. DRE is cracking down like crazy on those who use Craigslist, a free advertising medium, to advertise brokerage properties without disclosure. Clearly, the name of the brokerage firm must be in any form of brokerage advertising. Illegal in the state of Florida not to disclose at the minimum the name of the brokerage. So now, here we go again. This is run by a brokerage on Craigslist, legal or illegal?
Illegal.
Illegal. The name ABC Realty is not included, right? Legal, get the name ABC Realty in there.
Incorporated. It's also left
Well,
out of the
again,
top one.
It could have been ABC Realty, that would have been fine.
I don't know, one of the notes here said it has to have incorporated in it.
That's the registration of the entity. Let's not go there.
All right.
Separate. Now again, one of the benefits in brokerage is that we are allowed to buy and sell properties of our own, and we get the inside track.
Insider trading.
Now, if I'm selling my own property, I am a dealer, I am no longer a seller. If I'm buying, I'm a dealer, I'm no longer a buyer. I've got certain regulations of honesty and fairness in all of my personal transactions. But the duties of honesty and fairness and disclosure of licensee is not required in our advertising of property, but we do use it many times. So again, all I have to do is, I can advertise the property, Fabulous 22 on the beach, call Pete, 954-914-5649. But again, I want to be ethical, so I put owner agent in my advertising. I do it before, but again, law and rule says do it when you're in serious negotiations. Put the term owner agent in the purchase and sale contract so it's clear to the parties. Not required in advertising, but in negotiations. Now again, in the normal course of events, let me throw this back out there. Earnest money deposits. Also called good faith deposit, also called binder deposit, also called down payment, many names for the earnest money deposit. But let's use that $300,000
Property?
this is the offer, right? And the buyer has put $60,000 down in escrow. This is the money in question. Down payment. Now, again, that money is given to the escrow agent at the time of the offer. And again, the escrow agent must handle those funds properly. In essence, the buyer, when they made the offer, has given $60,000 to be held in deposit. And again, the escrow agent has to have that money in there, and it must be proven. You looked at the real estate purchase and sale contract that had the amount deposited, when deposited, name of escrow agent, address, phone number, etc., etc. It's fraud to say you deposited something that was not deposited. So again, anything of value, by the way, it need not be cash. It could be cars. It could be diamonds. It could be anything. It could even be love and affection. Now again, in the normal course of events, because frankly, it is such an annoying thing to make offers and have to have that money in escrow, what we state in our purchase and sale contracts is this. Check will be deposited in escrow upon complete contractual agreement, but we can hold the check out of escrow until such time, if noted clearly in the agreement. Now again, promissory notes. Again, someone can pledge stocks. That's okay. Now again, a broker will not be responsible for lack of funds to pay the deposit, but that will definitely kill the transaction. Now the term immediately in law has different meanings than the common vocabulary. It means this. Again, we have various ways of depositing escrow funds. Many brokers, to reduce liability and record keeping, keep them with title companies, and we work with those title companies, so they're glad to handle our escrows in exchange for us closing transactions with them. So again, the account is for the deposit of money held by a third party who has no claim to those funds, does not control them. Now again, when we use title companies which are authorized escrow agents in the state of Florida, there are 3 steps which must be taken. Again, you saw on the purchase and sale contract earlier the name, address, phone number of the title company attorney, which is on the purchase and sale contract. So again, that is a full disclosure of where the money is. In addition, if the escrow agent, the title company or attorney, does not give a receipt, it is the broker's responsibility to request in writing via certified mail a verification of deposit with that title company within 10 days of depositing the escrowed funds. And then a copy to the sellers, to the owners, broker or the owner themselves, the seller, with a copy of the verification from the title company within 10 business days. Now again, there are certain requirements for where escrowed funds may be placed. And again, real estate brokers may place escrowed funds in the state of Florida, specifically in the state of Florida, because that's where the property is. And again, it must be a federally regulated insured account within the state of Florida. So therefore, it can be in the state of Florida in a title company with trust powers. That relieves the broker of record keeping and other responsibilities other than to make sure the money's deposited with receipts. We may keep that money in a commercial bank, a credit union, or a savings association. These are all federally regulated insured accounts in the state of Florida.